Well, I'm attorney Dan Marr from the National New Hampshire law firm of Hamlin and Kerrigan. I've been practicing law here in Hamlin and Kerrigan for 37 years. Total years, about 38 years. The practice of law in New Hampshire, I did a one-year clerkship before I came to Hamlin and Kerrigan. Been there ever since. I've also been practicing in the Commonwealth of Massachusetts for about 28 years or so, 28, 29 as a Commonwealth. And I've practiced in both states, and I deal with a lot of real estate issues. I'm going to be talking today about real estate issues in New Hampshire, particularly what happens when you get a new neighbor and you've been living there on your property for many years, and the new neighbor says, I just got a new survey and you're on my property. Maybe they say your pool is on their property. Maybe they say your driveway, your portion of your house, or a portion of your yard is on the property. Maybe you got a lot of acreage, both of you. Maybe you have small, what we call postage stamped lots. They're just builder lots. All of that, it still matters. The land matters, and they're saying that you're trespassing. First thing you want to do is find out whether or not they have a survey. And if they do have a survey, you might want to have that survey reviewed by somebody else, because surveyors can make mistakes. I find them generally quite competent, but they're supposed to also work together to see what the real property lines are. There could be something from anything from a discontinued road that changes the dynamics to a bad deed reference, and all of those issues matter for the survey. The survey determines what the actual legal title is on the record. There are other things in New Hampshire that matter, though. So there's something called adverse possession, and adverse possession is if you have been acting like this has been your property, the property that the new neighbor says is surveyed, and they're saying that that is their property, and they want you off that property. You've been treating it as your own, and perhaps the neighbors before this neighbor, the ones that were owning the property beforehand, also treated it as your own. You have something called adverse possession. You got 20 years of continuous, adverse, uninterrupted, notorious possession of the property. You can win by adverse possession and have a determination that it is your property. Also, if you've been using the property for your own use regularly, you might have what's called a prescriptive easement. You don't have to. You can be in a situation where you don't have enough to show that you actually own the dirt, but you have a right to use the dirt for the same way you've been doing it for 20 years. So there's a process on that. There's also something called title by agreement, or basically when you and the neighbor for 20 years have stated, yeah, this is where the property line is, or you just agreed that that's where the property line is, and the other neighbor, the predecessor, says, yes, that's what we thought was the property line, you may have agreement, title by agreement. I've had those situations where both sides have actually agreed that that's what the property line was, and the new neighbor who thinks that they can change the way the neighbors have been working for 20 years can't do it. And I've had cases that have gone 40, 50 years, and you still have that new neighbor that thinks that they can get a survey and get it done. The surveyor themselves should explain also the risk of adverse possession and what that means to the homeowner, but sometimes if they didn't, or the person doesn't want to listen, you might still be in that situation. So I've dealt with these issues quite a bit. It's very important to understand what the use has been by yourself of the property. I can tell you that the mere mowing of lawn isn't enough. Even the planting of a garden may not be enough. There's got to be something that's really adverse that actually shows that you're treating the ownership. Fence, obviously, putting a building on there, putting a, extending your deck. A pool would be a very clear example of it. Also, one thing you want to think about too is I had a situation that was in Salem and went up to the Supreme Court where we were dealing with gardens and mowing of the lawns, and that in and of itself generally wouldn't be sufficient. But the predecessor of the neighbor said, yeah, that's where we thought the property line was. So when my client was mowing the lawn up to this particular edge, both them and us thought that that's where the line was. So when the neighbor before thinks that you're treating it as your yard, then that's adverse enough, because obviously you're meeting the adversity. And you do that for 20 years, then you're going to have the adversity that's necessary for adverse possession. You have to go to court for that. You have to get a judge's order to get title by adverse possession. But you can do that, what's called a quiet title action. You can do it in the I generally like to do it in the Superior Court, and it's well worth doing it. And I've litigated those matters, I've defended them, and also prosecuted them. Happy to help if the opportunity arises. I'm Dan Marr at 603-883-5501, 603-883-5501. You can check out my vlogs, weekly vlogs, on a variety of topics, all identified by topic, going to our website at Nashua Law, all one word, .com, nashualaw.com, and then click onto my bio, and then you can get onto my vlogs. Look forward to working with you. Opportunity arises. Thank you.